Welcome to JGL Law for You. JGL Law for You is a podcast by lawyers, but not for lawyers only. On JGL Law for You, we will be discussing a wide array of topics to help you navigate the many legal processes, developments in the law, other current events, and how they may affect you, your family, or your business. I'm back here today with my favorite and most frequent guest, my partner at Joseph Greenwald Lake, a family law expert, publishes articles, talks about all areas of family law here and elsewhere. Welcome aboard, Chris Castellano.
Thank you, David, for having me as always.
Yes. We're going to have to just get an office together, I think. But it's good for me because it's something I know a fair amount about. And what we're going to do today, and I'm glad you're here to help me with this, Chris, is to do something that we haven't done on this show before, and that is to do something on a very broad basis. And we're going to talk about the nuts and bolts of divorce here in Maryland from a breadth perspective. There's going to be lots and lots of issues and questions that people may come up with as they listen to this, but we're going to talk about it breadth and not depth, I like to say. Does that make sense?
Absolutely, David. I think it's important because at the end of the day, a lot of people facing these issues, the first question they always have is, what does it look like? What's the process actually look like? And hopefully that's what we can help to explain today.
I think you're going to do a great job. Let's start with the one thing that's always on folks' mind, and that is the costs, and not just financial, which I want you to talk about, but also emotional, mental health issues that arise during the course of a divorce.
A divorce is commonly viewed, and I'm sure you've heard this too, is that a divorce is viewed like a death in the family, right? And that inherently means that there's a significant emotional toll that a divorce plays on anyone and everyone involved. We always focus on the children. Children need therapy to go through the separation and the disruption, and that's an absolutely valid position to take. But that doesn't mean that you ignore yourself or ignore the realities of the opposing party. Everyone's dealing with a very emotional time, and that's a definitive factor in these cases, as I've experienced, and I'm sure that you've experienced. And it's a factor, an intangible above and beyond the very real, tangible, quantitative factor, which is the financial impact that a divorce has on a family.
Everybody always wants to know, what's it going to cost? To the extent that you can talk about costs financially, what does a divorce cost? What's the range? What might it cost? What might it not cost? And what can make things cost more or less?
Yeah, this is one of the most common questions, and it makes sense. We like to think of ourselves as a very fiscally responsible society, and so it's natural to wonder how much it costs. The problem is that, and it's not trite to say this, every case is unique. There's a case with a slew of issues that could come through the door, and everyone's on the same page. And you just write up an agreement that is a very quick agreement, and the next thing you know, they're getting an uncontested divorce, even with kids, because they sat down at the table and maybe figured things out, and it was fairly straightforward, right? And you're costing under $10,000 for something like that. But then you have the cases where every single issue is an issue. And when those cases come about, there's issues that crop up where you don't even think they're going to crop up. Whether it's, if you're in litigation, you've got different motions practice that ends up being necessary, various different hearings that end up being necessary to enforce obligations here and there, whether it's like discovery or what have you. And so the cost can get out of control very, very quickly. And as I tell clients, I can control costs from our standpoint, right? We can adjust how we approach a case. We can determine what type of discovery we want to engage in, but I can't control how difficult the other side's going to be. And a lot of the times we just have to react. And, you could do it in a very fiscally responsible way, but at the end of the day, a reaction is still necessary. And so sometimes costs inherently rise as a result.
And just along those lines, what, if anything, do you tell folks that they can do, aside from we can settle it or not settle it, that they can do during the course of the life of their divorce, that they can do to save money when it comes to legal fees?
So this is going to sound counterintuitive.
A lot of what we do is counterintuitive. That's not surprising me.
But one of the most important pieces of advice I give to new clients, particularly the ones that are very focused on saving money, is please do not handcuff me. And what I mean by that is if you call up your attorney every single day, if you give your attorney binders and binders and binders of information with your analysis, what you're doing is that you're taking the case out of my hands and the analysis out of my hands and now giving me a different set of issues to review. Now, instead of me looking at the issues as they lie, I'm also looking at what you've done. And it's appreciated that you're taking that time to invest in your case. But if you're at the same time being fiscally responsible, those two concepts end up being inherently opposed, right? And so what I mean by don't handcuff me, it is you hired me to do a job. And so you've got to let the tether go and let me do the job and know that I'm going to look out for your best interest, which includes your bill.
And that doesn't mean that client ought not ask questions or understand what you're doing, obviously, right?
I take a very collaborative approach with my clients. I like them to be involved. I seek their input on the types of discovery that I seek. And I always run it by my clients to say, hey, this is the direction I'm thinking of going, right? But what happens is that when you get the client that, let's just describe them as overeager, that says, hey, Chris, I know that you drafted all this discovery. I don't like these discoveries. You're not going to do that. These are the ones that you're going to do. Or I've already analyzed this. You don't need to analyze because I've already done that. It's a way that ends up rising costs in a way that we can prevent from the outset. Because again, we can't prevent the rising costs foisted upon you by the other side. That's a reality of litigation. But we can prevent and mitigate costs internally.
And I want to talk about the divorce process, and that's what we're here to do, is talk about process. But before we get to that, are there actions that stand alone? In other words, let's say there's a reason someone doesn't want to pursue a divorce at some period of time, but believes that custody issues or issues pertaining to their children, child support, custody, access, whatever it might be. Are there ways to pursue that without filing for divorce?
Well, yeah, you don't have to file for divorce in order to deal with custody, right? You could file a separate custody case. In Montgomery County, where you and I are both primarily located, the county does bifurcate our cases out to deal with custody first and then property issues in the divorce. And so to go back and tie in with the theme of being fiscally responsible, perhaps that's a discussion that you may want to have with your attorney, such as either yourself or me, because it may be cheaper in the long run to just do a one and done approach. Like, let's just file the divorce. Let's get it all taken care of right now. The court's going to bifurcate it. When you separate those issues out, you can create complications that may end up increasing costs in a way that you don't want to see.
Before we go further, I just want to point out to folks listening out there, we are talking specifically about what goes on in the state of Maryland, because that's where Chris and I are located. Keep in mind, if you folks are listening in other states, that those laws and those processes are likely to be not only a little bit different, but in some cases very much different. And the process itself, the procedures themselves, may differ from one county to the next, depending upon what state that you're in. So don't forget that as you listen here. Now, Chris, in the old days, and I say old days like a couple of years ago, there used to be multiple ways to seek a divorce, which is what we call grounds for divorce. I like to describe grounds. I like to tell people that grounds used to be sort of like the car that took you from married land to divorce town. But there were fault grounds, in other words, that somebody did something wrong, and no fault grounds where we just want a divorce or whatever the case may be. Now, what's happened in Maryland recently in terms of fault and no fault grounds for divorce?
Setting aside the potential rationale set before the legislature in Maryland, they simply got rid of the fault-based grounds. And what we have in Maryland now are three primary grounds for divorce. We have what's called mutual consent. We have 6-month separation, and we have irreconcilable differences. Now, we've all heard of irreconcilable differences because everybody's watched the movies, everyone watched the TV shows. It's in the societal zeitgeist to understand what irreconcilable differences are. Interestingly, what we have found in practice is that those old fault-based grounds, and what I mean by that is your classic adultery, cruelty, excessively vicious conduct, whatever it may be, those classic grounds, we fold them into irreconcilable differences in a way. Now, doesn't mean that you have to prove, like you used to in the old days, the fault in order to satisfy irreconcilable differences. But that's where we're now stuffing them in. We could talk about that in a bit. But as far as separation, it's exactly what it sounds like. You've been separated for 6 months. In Maryland, you can be separated, quote unquote, within the same household. So you don't have to physically be separated, but you have to be holding yourself out as separated, meaning, you're not continuing to act as a married couple. You're not going down to the Olive Garden for dinner on Saturdays and sharing, and husband or wife is taking the check, right? And then mutual consent is that you both sat down at the table, the kitchen table, you decided you want a divorce, and you've come up with terms. You agree to those terms that are all inclusive of all the issues. And then we write out an agreement, and then you get an uncontested divorce hearing based on that agreement. That's mutual consent.
So, Chris, let's talk a little bit about this fault and no fault grounds, right? On its face, it seems nice, right? It's nobody yells about what the other one did to them. There's no contention of cruelty or abandonment, desertion, adultery. All of those things are now gone. So it sounds like a good development. I mean, is that your perspective, or is there another side to it?
Well, I think there's always the positive intention, and changing from fault-based grounds to no fault-based grounds, I do believe was the greater intention was the theme of making divorces more accessible, right? And ensuring that people can get past go. I do think that there's a administrative reality to the fault-based grounds, as you well experienced and I experienced in my career, that, if you file a case based on cruelty or adultery, by the time you actually got to your divorce hearing, particularly in Montgomery County, you already had 12 months of separation. And so most of my cases back in the quote unquote day, I would just amend the complaint before trial for 12 months separation. So no matter what, I proved my case for divorce and we proceeded without issue. Now, there's certainly other motivations to changing the grounds from fault-based grounds to no fault-based grounds, but ultimately, I think it's fair to say that the primary motivation was access to the legal system for a divorce and possibly making it, quote-unquote, cheaper because of the lack of evidentiary necessity to prove the fault. That said, do I think that that's what we've seen? Well, at the end of the day, when a spouse knows that the other spouse has cheated and they're out for blood, they're going to want to prove that issue. They're going to want to prove that the adultery happened. Whether you and I or the judge likes it or not, it's still going to, at some level, feature in the case. And so, as I like to say, people are still going to get on the stand and slice and dice each other because that's what they wanted to do.
And the fault itself, although it's no longer that vehicle to get you from married to divorce, it can be a factor, right, in what a court looks at when it looks at financial issues, and maybe in certain cases when it looks at what's in the best interest of a child in terms of custodial or access issues.
Particularly when it comes to the best interest of the child standard, right? And, we're analyzing someone's judgment. If one spouse has been abusive of the other, that's inherently relevant information that's going to come out, that needs to come out. If one spouse has been engaged in adultery and they've been spending marital money on the adultery, and then you have what we call a dissipation issue, that's a central, critical, important fact for the court to know, the adultery. And so it's going to come out in that way. And as you said, what led to the estrangement of the marriage, quote unquote, that's one of the factors for items such as alimony. So the fault-based grounds, yeah, sure, we don't use them as a threshold to get into court anymore, but they're certainly still a relevant part of the divorce case.
Still alive. And the grounds themselves and the fact that there's no more fault grounds, and you mentioned that it makes the system more accessible. There are folks both in the legislatures here in Maryland, elsewhere, as well as Congress, I think that think that it's a bad thing. No fault divorce is a bad thing because it makes it too easy, right? It makes it too easy to get out. And maybe it shouldn't be that easy. I'm not arguing this position, but maybe it ought not be that easy to get out of something that you should have taken seriously when you got in, right? I mean, that's certainly one perspective. Okay. We could probably talk about philosophy forever. Let's not do that. Let's stick to our goal here, which is to talk about process. But I do want to talk about one more thing before we end part one of this nuts and bolts of divorce in Maryland discussion. And that is the concept of limited and absolute divorce that existed until recently in Maryland. Could you talk a little bit about the differences, why there's no more limited divorce in Maryland, and what people may see, if you know, in other jurisdictions?
Yeah, absolutely. So limited divorce was offered in Maryland until relatively recently, and it was a way to get you in the door, right? You could. Yeah, another way to think of limited divorce, and the way that I was taught in law school, was this is another word for legal separation. It was a way to legally separate from your spouse. And this goes back to the days of kind of what you referenced, right? Is that divorce process shouldn't be easy, right? It was disfavored to disrupt the nuclear family concept for society. So you had to go to court to get a legal separation to allow you to start going down this road. As time has gone by, we, as a legislature and a Maryland society specific to Maryland, we have gotten to the point where we believe that perhaps it should be somewhat easier, right? And we have slowly but surely decreased the time for separation. We've decreased various different inhibitions on accessing the divorce process. And as a consequence, a few years ago, we eliminated the limited divorce. Of course, there's a practical reality to it too, right? Which is that ultimately, once you file for a limited divorce, by the time you get to a trial for a limited divorce itself, you've essentially already gotten the 12-month separation as it is, so you can get the absolute divorce. And so we would all just amend our pleadings for a absolute divorce. I mean, the amount of times in my early career, that I filed a limited divorce complaint or in the alternative absolute divorce. I mean, what are we doing at that point? And I think the legislature recognized that as well.
All right, so folks, we're going to stop here. This is a lengthy discussion, so this is going to end part one of our nuts and bolts of divorce in Maryland, what the process really looks like. Come back next time for part two, where we're going to pick up with the litigation side, how that works, the potentials for settlement, and then what happens after divorce. So everyone, I want to thank you, Chris, for joining us as always. And just to remind everyone, what's the best way for them to get hold of you?
I am available anytime to have a phone call. You can email me. My contact information is on our website, jgllaw.com. My email is ccastellano@jgllaw.com, and I would be happy to discuss this podcast, any of our prior podcasts, or any issues you have.
Awesome. Thank you, Chris. And everyone, again, thanks for joining us. Come back next time for the second part of this discussion. I am David Bullitt, and this is JGL Law for You.